Good morning, everybody. I'm your host, the Supreme Litigant, and I'd like to welcome everybody back to Smart Loc TV. Before we begin, if you haven't already, please go ahead, hit that like button, hit that subscription button, and turn that notification bell on. Give y'all a few seconds to do that. All right, y'all. This will be part two of this video right here. Always do this before entering a plea. But in this video, I'm going to actually draft the motion from scratch, and it's going to be based off of Ohio. It's going to be based off the Ohio case law and criminal procedure. So let me get into it. Give me a second. Where's my Microsoft Word? Right here. Okay. So we're going to say that the so-called charge against you in this particular case is resisting arrest and disorderly conduct. But you have determined, once they served you a copy of the complaint, that the complaint fails to properly invoke that municipal court's so-called court anyway, subject matter jurisdiction. In other words, it fails to properly invoke its jurisdiction. Now, you need to, when they do this, you have to be able to point this stuff out. And even if you are able to point it out, they will still ignore you and then just act like they don't know what you're talking about. But you have to remain firm, and you have to assert your rights. All right. So let's go ahead and start. So we're gonna say, let's look up a let me go to Google. I'm gonna see if I can find a city in Ohio. So we're gonna go to Google, and we're just gonna make this stuff up. City, let me see, cities in Ohio. Okay. Cincinnati, Springfield, Middleton. Okay. Columbus, Ohio. We can do that. We'll say, let's see. I'm sure they have a municipal court. We're gonna say Columbus, Ohio. Columbus, Ohio. Columbus, Ohio Municipal Court. Okay, there we go, right there. So it's in Franklin County. All right. All right. All right. So let me make sure I got it right though. I got to make sure I got it right. Franklin County. Whoops. Cities. So let's see what all they got in here. Franklin County cities. I don't see, this might not be right. I don't see Columbus on here anywhere. It's in Franklin County, Bexley. Okay, there it is right there. All right. Let me make sure though. I'm sorry, y'all. This is just the stuff that you got to go through, well, that I have to go through just to make sure that I'm doing it right. Cities in Franklin County. Bexley. Okay, there we go. So Columbus. All right. So let's go to the document. And we're going to start drafting. I'm drafting this from scratch. All right, from scratch. All right. So in the municipal court of Franklin County, state of Ohio. Put that right there. I like to make mine. I probably let me see. That's the font color. I'll change the way it is black. Let me see if I can bold it. There we go. Okay. State of Ohio. Let's go down over here, and we're gonna say City of Columbus. All right. Where we at? Right here. 1, 2, 3, 4. That looks okay. Then we're gonna put the case number. Just gonna make up a case number. 1, 2, 3, 4, 5, 6, 7. All right, that's the case number. All right. And we're gonna say, because this is exactly what it is, we're gonna say in administrative agency and corporation. That's exactly what it is. All right. So we're gonna capitalize that. Make sure I spell this right. Administrative agency and corporation, because that's what it is. Boom. All right. We're gonna go down versus that. 1, 2, 3, 4, 5, 6, 7. All right, that's cool. I like that. I like the way it's looking so far. And we're gonna say John Doe. We're gonna always use John Doe. John Doe. Privacy purposes. I like to label like stuff like this. I like to label it something like this. Let me see. Legal fiction. Got that. Something like that. That's how I like to do mine. Because that's what it is. That's exactly what it is. A surety. It's a legal fiction. It's a dependent. All that stuff. All right. So I think I got too many spaces in here between here. So let me see if I can fix that. Let's do 1 point. That's too much. Let's do 1. Looks like it's still too much, but let me see if I can fix it. It must got like yeah, right here. That's what it has. And okay, that's too much. I mean, let's go about right. I'll leave it like that. All right. So we'll leave it like this. And I'm gonna put this, I'm gonna bold all it, not bold it, but do it like that because that's what it is. And it belongs to a territorial government. So the city of Columbus is a territorial government. It is also an administrative agency. It was created by statutes, you know. So, all right. Now we're gonna get into drafting the title of it. So we're gonna do a motion to dismiss for lack of, we'll say, due process, or we'll say for lack of subject matter jurisdiction. But I mean, that's pretty much the same thing. Motion to dismiss for lack of due process. Yeah, we can do that. Lack of due process. I like that. And then I'm gonna substantiate what I mean by that in a minute. All right, so we're gonna say comes now. Let me take the bold off. John Doe. Herein after. There we go. Herein after. What are we gonna say? We'll just say Doe. Whatever, because it clearly just, I mean, it's already drawing a distinction between the two anyway. Up here, that like right here, that's what it's doing. It's already the distinction is already drawn. Okay, so we're gonna say under duress and on a special appearance. So a special appearance is solely just is for challenging jurisdiction. That's what a special appearance is. I'm going to say pursuant to the due process clause. I mean, we're gonna use both. I know some of y'all probably gonna not want me to make this 14th Amendment argument, but I'm gonna make it anyway. I mean, I know some of y'all probably don't want me to claim, rights under the 14th Amendment, but I'm gonna do it anyway, just in this video. And I'm gonna do it under the Ohio Constitution as well. Due process clause of the 14th Amendment. Whoops. I do this a lot, y'all. That's how I know what I'm doing. Like I do this a lot. The so-called law or anything that I think that is important, I always bold it so they can see it. Like right here. Hold on. Anything that I think is important, it will always be bolded. No, I probably spelled Constitution wrong. All right. All right, we'll take the bold out. So let me go and do some research right quick because I have to find the due process clause under the Ohio Constitution as well because I want to allege that as well too. So we're going to go back. We're going to go to the Ohio Constitution, Article 1, Bill of Rights, right here. Inalienable rights. So let's see. Oh, no, this one ain't it. Oh, men. I want y'all to notice, like when you're reading these statutes, you're not going to see the word men in there by nature. You're not going to see the word people in there. I've almost never. I think I might have seen it maybe once, but I've never seen it twice. Let me get back to it. Freedom of speech, trial for crime, witnesses, bail, risk may be slavery, transportation. I believe this is it right here. So it looks like Article 1, Section 16. All courts of open reputation, due course of law shall be administered. Suits may be brought. No, that's not. I don't think that one is. I think it's this one. So it might be Article 1, Section 10. No person shall be compelled. Let me see. Impeachment, they were penitentiary. Yeah. Shall be allowed to appear and defend in person or and with counsel. What this means is you and your attorney can argue this case, not just your attorney. Both of y'all can argue that case. to demand the nature and cause of the accusation against him and to tell him witness in process. Accused by state against him, such deposition, facing witness shall not be deprived. That's what I'm looking for, and I don't see it in here. But I know it's got to be somewhere. Give me a second, y'all. I gotta find it. Protect property, private property, reservation. Powers reserved to the people. No hereditary privileges, search warrants, quartering, firms, freedom of speech. I'm gonna have to look it up another way. So I couldn't find it here. So what I'll do is I'm gonna look it up another way. It should be somewhere. So I gotta go here and do it. So I want y'all to pay attention how I do it on here. So we are in Ohio. So we want to be very specific. We want to go down till we find Ohio. Click on Ohio. Apply jurisdiction. No cases are going to pop up because we haven't put any words in here to search for. So we're going to say life, liberty, and property, due process, Ohio Constitution. All right. This is a search engine, okay? You always want to hit parallel search. I'm going to show you the distinction between the two. So this is going to be we're going to do keyword search first. So keyword search just allows you to look up cases by the word. It's just going to highlight the keywords that you put. So let me show you what I mean. It's only going to highlight the keywords. See that? Right there. So let's go here. It looks like it's in Section 16, Article 1 of the Ohio Constitution. Both provide that no person shall be. Let me see. Was it Articles 1, Section 16? I didn't see that in there. I must have overlooked it. No imprisonment, redress. Oh, okay. They must have changed it then, but we're going to see. We're going to see. Let's see if we can find something up to date. So you get parallel search. You get a better search with parallel search. That's 1953. 2011, the Due Process Clause of the 14th Amendment of the United States Constitution, blah, 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 and the Due Process Clause of the Ohio Constitution provides similarly, Section 6, in the criminal trial, the defendant has the right to due process is the essence of right to fair opportunity. Okay. So according to these cases, it is Article 1, Section 16, which was throwing me out. That's why you got to read cases. So this is the oldest case, right? I'm sorry, the latest case right here from 2024. The 14th Amendment of the United States Constitution and Article 1, Section 16 of the Ohio Constitution provides that no person shall be. Okay, there we go right there. So this is the case law right here. So we're going to say, let me show you what we're talking about. We're going to do it like this. So we're going to bring it under the Due Process Clause of Article 1, Section 16 of the Ohio Constitution. And then we're going to say, and the 14th Amendment of the United States Constitution. Or we can just say, I like to do it like this. I'm just very detailed in my work. We'll do it like that. And we're going to say right there. All right. So it's Article 1. And I actually like to use the statute sign, subsection sign, if that makes sense. I actually like to use that symbol in mine just to free up some space. So let me show you what I mean. We're going to say, see if I can find it on here. It might not let me do it. So I'm going to copy and paste it on here and see if I can change it and make it look look right. Oh, there it is. Okay, good. All right. Section 16 right here. All right, so now we're going to bold this. Y'all know this is how I do it. I do this for when people read my work, like people who I teach. I do this so they can see it. I highlight this stuff so they can see it. The stuff that I highlight is very important. These are the authorities that I'm using. All right. So let's make sure. All right. So we're gonna say because this is an administrative agency, so I'm gonna do mine like this. Y'all can do y'all's a little different. You know, you can you can make it say whatever you want. I'm gonna do mine like this. We're gonna say to respectfully demand a showing in the affirmative on the face. Oh no, we're gonna say on the record. On the record of these non-judicial executive administrative proceedings, because that's exactly what it is. Every essential prerequisite, no, I'm probably throwing y'all off, prerequisite factual element of the offense. See, of the offense, what else we got? For factual element, we're gonna say factual elements. We'll say, let me see, as to subject matter, the subject matter jurisdiction, and they have to tell you the you know the nature of the action. You know they when they bring the case against you. Trying to see. They have to inform you of it. So how are we gonna word this? Subject matter jurisdiction, and we'll say and nature of the accusations or dismissal for lack of due process. Forthwith. That means immediately. So I'm gonna try to break this down a little bit. So I'm gonna read it to you. Comes now John Doe, hereinafter under duress and on a special appearance, pursuant to the Due Process Clause of Article 1, Section 16 of the Ohio Constitution, and the Due Process Clause of the 14th Amendment of the United States Constitution, to respectfully demand a showing in the affirmative on the record of these non-judicial executive administrative proceedings every essential prerequisite factual element as to the subject matter jurisdiction and the nature of the accusations, or dismissal for lack of due process, forthwith. And we're going to say in support of this motion, Doe avers the following grounds. I might make that a little smaller. This might make that into like an 11. Or let me see how to look as a 10. We'll leave it at an 11. I like 11. All right. All right. So let me go over this. Okay. Now we'll make the we're going to make the first argument. So we're saying that the complaint is devoid of the prerequisites. In other words, we're saying that the complaint fails to properly invoke this administrative agency's, aka so-called court's, subject matter jurisdiction, because it doesn't have all of the ingredients that it needs to properly invoke its jurisdiction. Give me 1 second, I'll be back, y'all. All right, y'all, I'm back. Sorry for the delay. All right. Oh yeah. Okay, we're down here. So we're gonna start with number 1. Okay, number 1. So like when these numbered paragraphs right here, these are your grounds. These are your reasons for making the argument that you're going to make. So, they have to give you, when they arrest you and stuff like that, generally speaking, they have to give you, the arrest warrant, or anytime they're prosecuting you. Like, for example, the complaint needs to have the facts in it in support of probable cause. So essentially, what they're saying is when they file this complaint, even though they're not actually saying it, it should actually say it in the complaint, but they're going to be arguing that there was probable cause for the complaint. That's what they're going to be arguing. So what we're going to do is, I'm going to say Doe avers that, and I'm going to incite some case law in here. This is the reason why I'm doing this, is because I already know this stuff. So I really don't have to go and read the case. I can see a case citation and I can read it and, determine if it's true or not just by reading the case citations. All right, so let's go back to here. We're going to clear out of Oklahoma for right now, Ohio. Well, we're going to leave that up. We're going to leave it up. We're going to go back here. Back here to case text. I don't know what is all this stuff popping up on here. And we're going to use the search engine again. We're going to say, we're going to make an argument about probable cause. So I'm going to say prob cause exists upon reasonable conclusions drawn from officer. And we'll see what we get, because that's how they're supposed to come up with it anyway. Whether probable cause exists depends upon the reasonable conclusions to be drawn from the facts known to the arresting officer at the time of the arrest. And that is true. That is 100% true. Let me see if they actually have that in Oklahoma. Not Oklahoma, Ohio. Let me see if they got something very similar to that. If they do, we'll just use that. If not, I'm gonna just go back and use the U.S. Supreme Court cases. Okay, well, yeah, we can. They're citing the case that we just read. So it says whether probable cause exists depends upon the reasonable conclusions to be drawn from the facts known to the arresting officer at the time of the arrest. So what I'm going to say is this. I'm going to copy and paste this. Right here. We're going to paste that right there. And we're going to put it in quotation. So I do my stuff. Yeah, I like that. Might make that into an 11. I always make these into like an 11. Something like that. Where's that case at again? It's a very good case. And we're going to cite both of these cases. So I'm going to copy that and paste it up here, this case, and I'm going to go and find it right here. I'm going to get the case citation. See right here? So I'm going to click copy citation because I already know this to be true. I don't have to read the cases. I've already read the cases. So I would advise y'all to read the cases, though I've already read the cases. So I already know that this is true. Where we at here? And I'm going to do this right here. C, and then I'm going to paste it right there. And I'm going to say citing, and there we go. Or I will put like a footnote or something in there. Yeah. So we're going to bold that, make that into an 11. And we're going to, whoops, hold on. I don't know what that was. I don't even know how did that happen. We're going to italicize it right there. Whoops, hold on. I'm very picky with how I do my stuff, y'all. I'm sorry. Y'all like it's not even that serious, but yeah, it is to me. All right, that's one. That's one reason, you know. Now we're gonna go with the other reason, and then I'm gonna say, oops, let me get this bold off here. Doing that. Then I'm gonna say, though averse, that the complaint is conclusory. Conclusory. I'm gonna say it's vague because it's not clear as to what they're talking about. It's vague. Conclusory. What is it doing? Okay. Hold on, y'all. Okay. Vague, conclusory, and devoid of the prerequisite. You're going to copy in this. The prerequisite factual elements as to we'll say of the offense. We're going to say of the offense. Of the offense. Of the offense. And, whoops. And therefore fails. We're going to say and is therefore legally insufficient as a matter of law. Yeah, I don't have to do that. Decide do mine. They gonna know exactly what you say When you say that, all right, they probably gonna act like they don't know what you're talking about, but they know what you're talking about. I'm telling you what I know. um, what else? There's another one. Let me see. I'm thinking right now, y'all. So give me a second. Give me a second. Also, yeah, the sign averts that the complaint mm, I think I'm gonna put that one up there. Give me a second, y'all. I'll be right back. All right, y'all. Sorry about that. So, I'm gonna go ahead and I'm gonna change this around a little bit. But I also want to I forgot to tell y'all this. When they don't give you the facts in which they're basing their complaint on, you know, for trying you or whatever, if that makes sense. When they fail to do that, they fail to protect you against double jeopardy. So you want to put that in there too. So we're gonna say double averts that the complaint is vague, conclusory. We're gonna take out "and" right here. We're gonna say devoid of the prerequisite factual elements of the offense. Let me see. Devoid of the prerequisite elements of the offense. Fails to protect Doe against double jeopardy. Double jeopardy. And is therefore legally insufficient as a matter of law. Let's see. I like to copy this. I mean, not copy it. Capitalize it. I'm sorry. Okay. Let me see what else I will put in here. There was something else. Probably gonna put some footnotes in here as well. I think that's what I'm gonna do. So we're gonna do some more research based off what I already know. Do I still have Ohio selected in here? Yeah, okay. So we're gonna keep using Ohio because we're in Ohio. But we're gonna be using federal cases as well. If I can find any. So let me see. Let me see. Due process. Protect. Defendant. Whoops. I'm doing this off the top of my. I'm just making something up, y'all. Protect defendant from conviction. Proof. Reasonable doubt. Proof. I'm gonna say element. I'm gonna put elements in there too, just to see if I can find something. Let's see what we get. Okay, I like that. Got 2019, 2014. Okay, State versus Hobbs. Let's see. The first assignment of errors without merit. Let's see. The Due Process Clause of the 14th Amendment to the United States Constitution protects the defendant from conviction, except upon proof beyond a reasonable doubt of all of the elements included in the definition of the offense of which the defendant is charged. Okay, I think I'm going to put this one in here because they don't allege any of the elements in the complaint. The factual elements, that's what they have to allege, and they fail to allege them. So we're going to go here. So I'm going to put this in the complaint. I'm probably going to use it as a footnote. This video probably going to be about an hour, y'all. So just bear with me. All right. I got to figure out where I'm going to put it at in here, though. I can put it right there. I think that's perfect. I'm going to put it, it's going to be right there. So let me go here. I just copied that case just to let y'all know, and I'm about to insert a footnote. So we're going to go to insert. No, I got to go to references. Yeah. Text, insert, footnote right there. All right. We'll go right there. We'll go C, yada, yada, yada. And we're going to do it kind of just like the other one, citing. Where is it at? You got to go down to it. Right down, here we go, right here. Right here. We're only going to copy this. Right here. We're going to copy that. That's the law. This is all their paralegals be doing too, y'all. This is what they be doing. So you really don't even have to say citing that. You can say holding that because they're acknowledging it. You can say holding. Yeah, we'll do it like that. I like that better. Hold on, y'all. Try to finish this on. I don't want to make this video too long. Back home. Gonna bold that. Make sure it's Times New Roman. Let's might keep that at 11. Yeah, we'll keep that at 11. Well, no, I don't know what we're gonna do. It's good. Here. Times New Roman. Make that black. Everything black. We're gonna take out the underline because I don't like that. We're gonna bold that. Make that like that. And I think I'm gonna make that a 10. Yeah. We'll keep this font at an 11. Make that a 10. Gotta fix this one too. Times New. Was that 10? I like that. That don't look bad. Well, no. Make that an 11. Make this an 11 as well. There we go. State versus and we will bold that at a 10. I think that's it. Yeah. I'm gonna take some of this out, take that out, and we'll just leave it just like that. All right, I like that. I like that a lot. All right, y'all. Let's see what else. I think there was Okay, yeah. I need to make another argument. Mm, all right, and we'll make Give me a second, y'all. I'll be right back. All right. So let me get back to this, y'all. Sorry about that. I'm gonna add something else in here. So we're gonna say, the complaint is vague, conclusory, devoid of the prerequisite factual elements of the offense. We're gonna say to establish probable cause. To establish probable cause. Fails to protect though against double jeopardy, and therefore is therefore legally insufficient as a matter of law. There's something else in here because this is a municipal court. So what in Ohio, according to what I read, you have to file the complaint in the manner mandated by Rule 3 of the Ohio Rules of Criminal Procedure. So I'm gonna see if I can find me a case. Let me see something. We're gonna say a valid complaint. Let's do it like this. Should be something. A valid complaint under criminal rule 3 must contain, we'll leave it like that and see what we get. Okay, that's good. We'll use this one. This one is the latest one from 2024. The purpose of the complaint is to give the accused adequate notice of the crime charged. Criminal Rule 3 governs the requirements of a valid complaint in Ohio and provides, in relevant part, that a complaint must contain the essential facts constituting the offense. Let me put in, let me get a little bit more detail. Facts, and we're going to go subject matter jurisdiction. Let's see what we get now. More specifically, the filing of a valid complaint pursuant to Criminal Rule 3 invokes the subject matter jurisdiction of the court. There we go. Furthermore, the filing of a complaint against a defendant invokes, there we go, right there. Okay, that's 2017. To invoke the subject matter jurisdiction of the municipal court, a plaintiff must file a complaint that is valid under Criminal Rule 3. Okay. So in other words, a complaint that meets the requirements of Criminal Rule 3 invokes the subject matter jurisdiction of the trial court. So what this implicitly says is a complaint that does not meet the requirements of Criminal Rule 3 does not invoke the subject matter jurisdiction of the trial court. So we're going to use that. I like that. you can draw reasonable conclusions, from this stuff. Let me see. There was something else. I'm gonna use this one. I like this one right here. Go here. Let's make this search more faster. Oh, let's see what we got. It's 9, 2019, 52, 52. Here we go, right here. Now, they're telling you how to do it right here. I'm gonna read this stuff to y'all. You can't waive subject matter jurisdiction, so it doesn't matter if you bring that argument up or not. I think I'm gonna read all of that to y'all. Let me see. Let's go. I think we'll stop about at 24, paragraph 24. So we'll start up here and see what we get. We have music outside. Give me a second, y'all. Let me close this window. I'll be right back. All right, y'all. Sorry for the delay. I'm back. So we're gonna jump right into this. I wasn't going to read. I didn't plan on reading too much from a case, but there's a little excerpt in this case that I want to read to y'all. So this video is gonna be a little over an hour. So just come back and watch it whenever you can. We're gonna start here. All right. So this is the city of Columbus versus somebody else. Excuse me. The Supreme Court of Ohio described subject matter jurisdiction of a municipal court in state versus, I don't even know how you pronounce that, but anyway, the term jurisdiction refers to the court's statutory or constitutional authority to hear a case. The concept encompasses jurisdiction over the subject matter of a case as well as jurisdiction over the person. Because subject matter jurisdiction involves a court's power to hear a case, the issue can never be waived or forfeited and may be raised at any time. Go down a little bit more. Municipal courts are created by statute, and their subject matter jurisdiction is also set by statute. What this means is that municipal courts are statutory, or in other words, administrative courts. In other words, they are inferior courts of extremely limited jurisdiction, meaning their authority is extremely limited as to what they can do. A municipal court has jurisdiction to hear misdemeanor cases committed within its territory. That's because it's a territorial government that you're dealing with, and has jurisdiction over the violation of any ordinance of a municipal corporation within its territory. The ordinance is a bylaw. The statute is a bylaw. Thus, pertinent to this case, the Franklin County Municipal Court has subject matter jurisdiction over misdemeanor cases committed within Franklin County and violations of City of Columbus ordinances defining criminal misdemeanors. All right, pay attention, y'all. However, to invoke the subject matter jurisdiction of the municipal court, a plaintiff must file a complaint that is valid under Criminal Rule 3 and paragraph 1 of the syllabus. A complaint that meets the requirements of Criminal Rule 3 invokes the subject matter jurisdiction of the trial court. And then they're going to define what a complaint is. Now, I've already did that in part 1 of the video, so we're not going to do that. What I'm reading, y'all, is principles. This does not just apply in Ohio. This if it's a court of limited jurisdiction, so-called court anyway, in other words, it was created by the legislature, the statutes, and their jurisdiction is extremely limited. And whoever is attempting to invoke their jurisdiction has to do it in the manner required by the statute or the rule. That's it. And if they don't get all of the elements that they need to properly invoke its jurisdiction, then it doesn't have jurisdiction. And y'all need to be very careful and do your research, because they will act as if they have jurisdiction when they clearly do not have it, because the plaintiff has not properly invoked it. They will do that. All right, so we're going to start right here. Thereafter, so after a valid complaint is filed, a defendant must raise before trial any challenge to either the validity of the complaint or a defect in the institution of the prosecution that is not a jurisdictional bar. The failure of the defendant to raise such defenses or objections constitutes waiver. And you can see that in Ohio Rules of Criminal Procedure Rule 12H. That's what they're talking about. Finding that the defendant's argument regarding the trial court's lack of jurisdiction based on a complaint alleged to be procedurally defective under blah, blah, blah was waived where the defendant failed to file a Ohio Rule of Criminal Procedure 12C motion prior to trial. So they're saying procedurally, not substantively. Procedurally. So they must have been some sort of service or something like that. I'm not really sure. But anyway, I would have to go and read the case. But anyway, however, when the flaw in the complaint or indictment is a jurisdictional bar, such as failing to charge a valid criminal offense, or in other words, failing to charge any offense, the trial court is divested of subject matter jurisdiction and any resulting conviction is void. Finding that the trial court should have granted appellate's motion to dismiss for lack of subject matter jurisdiction because the statute charged in the indictment had no accompanying statutory penalty, and therefore the indictment did not charge a criminal offense. So in other words, what they're saying is, anytime the city files a complaint against you or an indictment against you without the essential facts constituting a violation of that statute or whatever, then the indictment, or if they did a complaint, it fails to charge an offense. So in other words, it fails to properly invoke its subject matter jurisdiction. Here, the appellant does not argue that the complaint as initially filed was invalid, so they're not arguing that. And on our own review, we find that the complaint in this case was valid under Rule 3 of the Ohio Rules of Criminal Procedure. The complaint is made under oath and states the numerical designation of the applicable ordinance and the essential facts constituting the charge. Those are all of the ingredients that it needs to be in a valid complaint. Thus, unlike blah, 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 subject matter jurisdiction of the trial court was properly invoked at the outset of the case. All right, so we're going to use this. This was a pretty good case, a real good case. So I'm going to use this. I'm going to pick it apart and see what do I want out of here. I like this, so I'm going to put this in here. We're going to copy and paste that. I like that. I'm going to put it in a footnote, though. And I think right there will be pretty good. I'm kind of a little rushing through this just a little bit, y'all. So just bear with me. Where we at? References. I'm gonna add another footnote. And we're gonna do this right here. I'm gonna say though averse. And we're gonna say, and we're gonna cite the case right after it. This was a pretty good case. Started at 20, yeah. Pretty good case, man. we'll do it like this. Well, no, I think that's pretty good like that. I mean, it pretty much says what I wanted to say. Yeah, it pretty much says what I wanted. I think I'm gonna add something else right here. Yeah, I'm gonna add something else right after that. And I think that'll probably be it because I don't want to make this video too long. So what we at? State versus egg. I'm not even sure what I got out of this video. I mean out of this case, but we're gonna say indictment, affidavit, complaint, complaint must essential facts or I'll say invalid. Let's go back. Let me use parallel search. Indictment. All right, let's see what we get. Okay. 24 to see. Therefore, the law of Ohio has consistently held that an indictment, affidavit, or complaint must set forth all of the essential elements of the crime charged, or it is invalid. Okay, let me see if I can find like the latest case. If not, then I just have to use one of these old cases. 2003, 94, 6, 2021. So we have previously confronted this issue and held that the lack of a specific probable cause finding on the face of an indictment does not render the indictment void. So they're probably going to let them cure it. Thus, an affidavit and complaint are not necessary when an indictment. Okay. Otherwise, such affidavit, complaint, or indictment or information. Oh, that ain't it. He argues that since the complaint and warrant were invalid, the indictment was likewise invalid, and therefore his conviction cannot stand. That's not it. Let me go back up. So I guess I will use the latest one here. Offense which he is charged. In this case, count two felony of the indictment read and printable that unlawfully caused the death of the victim. Let me see if it's gonna let me on there. It might. Let me see if I can click it. It might let me click it. Nope, it ain't gonna let me do it. Okay. 2014, Ohio Court, appeal March 27. So it's this one right here. All right. Initially, we note the objections based upon lack of subject matter jurisdiction. Okay. We review the determination of subject matter jurisdiction de novo. So they're going to look at the entire case over again on appeal. Okay. A criminal case may be brought by indictment, which is procedural, not jurisdictional. A criminal case may be instituted not only by a complaint, but by an indictment or an information. Complainant would render harmless at the issuance of the indictment and had no effect upon the subject matter. All right, let me go. So let's go here. And I'm going to see which cases. Let me see if I might be able to find some new cases that cite this case. 46. It's 46 of them. 96, 1984, 82, 2020. This, let me go back. I'll just use this video already over an hour long anyway. All right, y'all. Thank y'all for being patient with me, by the way. What is this? Is this the right case? No, this ain't it. It's right here. Okay. We'll do it like this. Let's put that right there. There we go. All right, I like that. I'm gonna go ahead and try to wrap this video on up, y'all, because it's already over an hour long. Times New Roman. Back. Right here. All right. Get that in now. That in. It's 10. All right, I like that. Now we gotta make this bigger. Make that an 11. Make it a little bigger. These words are too small. This video, I also made this for people who come on this channel telling me I don't know what I'm doing. I'm gonna leave it like this. I mean, I want to finish it, but it'll take too long. So I'm gonna go ahead and just add a signature block and a certificate of service on here, and I think that'll be it. This is just a sample, y'all. So let me add a signature block on here. And we're gonna say John Doe. Did I do that one? Oh, there we go. Let's say John Doe. We're gonna put right here. I might put like agent or something like that. I'll put this chief executive administrator. Something like that. Or you can if you wanted to put defendant or whatever, you can put alleged defendant, whatever. I just like to put something that distinguishes me from the legal entity. Then you put your address. We're gonna go 123 Freedom Street, Liberty, Ohio. I'm just making something up. Not even sure if that's real. Zip code 12345. All right, we'll go down. We're gonna put a certificate of service on the bottom of it. Well, gotta put a conclusion on here too. We got the conclusion. Conclusion. We'll put a demand. I'll put a demand for relief. There you go with the old, this is what I always do. Wherefore, though respectfully demands dismissal of this case forthwith. Forthwith means immediately. Let's make this a little bigger. And we'll put a certificate of service on here. Certificate of service is just you're certifying that all of the parties to the case, you have furnished them copies of it so they can get it. Because you have to serve everybody. They have to serve you everything, and you have to serve them everything. And we'll say, oops, Doe certifies that on this, what's the day? 21st, on this 21st day of September. All right. Dang it. I like to capitalize my stuff. 21st. He has served a true and correct copy of this motion on all parties to the case. And there we go, something like that. I bold this, bold it all up, might make it a little smaller, something like that. And that should be it. You had to put a signature down here, the certificate of service too. But generally speaking, this is really how you do it, y'all. It normally takes me longer than this because I like to make sure I do it right. And if I have to do some new research, I like to read the cases and so on and so forth. But this is pretty much how you do it. Pretty much how you do it. And that's pretty much it. Normally it would probably be longer than this, probably be more detailed than this, so on and so forth like that. But I just don't have the time to do it today. Hopefully this video helps y'all. If it does, please let me know. If it doesn't, let me know what I can do better in the next video. So that'll be the end of this video. Supreme Litigant is out. Peace.